Okay, good evening, lovers of law. I will be your virtual companion of studying unenforceable contracts tonight. Now, let us start with the definition of unenforceable contract. It is one which cannot be enforced in court or sued upon by reason of, take note, certain defects provided by law until and unless they are ratified according to law, while rescindable contracts and voidable contracts are valid and enforceable unless they are rescinded or annulled. Unenforceable contracts, although valid, are unenforceable in court unless they are cured or ratified. Take note that the defect of an unenforceable contract is of a permanent nature, and it will exist as long as the contract is not duly ratified. The mere lapse of time cannot give efficacy to such a contract, and that the defect is such that it cannot be cured except by subsequent ratification of the unenforceable contract. Now, what are the different kinds of unenforceable contract? We have here, number one, those entered into by the name of another by one without or in excess of authority. Number two, those that do not comply with the Statute of Frauds. And number three, those where both parties are incapable of giving. Now, this is a summary of Article 1403. Okay, you can turn your books to page, charot. You look for your codal, guys, and check what page is it. But you also have a copy of the article here. Article 1403, the following contracts are unenforceable unless they are ratified. Those entered into, Yan nga. Ano ba yung sinasabi niya dyan? Na entered into a name of another name of a person. So, actually, it is not inexistent if entered without authority. Okay? Obviously, a contract entered into by one in behalf of another without authority is made without the consent of the latter. Nonetheless, the contract is not inexistent nor void, but unenforceable. An inexistent or void contract may not be ratified, but this kind of contract is subject to ratification. So even if the alleged principal did not ratify the contract made in his behalf without authority, the contract does not become void but cannot simply be enforced against him. So that here it is not in existence if entered without authority. It's just that it's unenforceable. Okay? The second, however, this does not apply to a sale of parcel of land. Why? Of course, in the sale, if an alleged agent has sold a parcel of land without the consent of the alleged principal, the contract is void and not merely unenforceable. And why is it so? Because under Article 1874 of the Civil Code, it requires the authority of the agent to be in writing in case of sale of a parcel of land or any interest therein. Otherwise, the sale is void. Okay, so that's the first one, first type of unenforceable contract. Now let's move to the second one, those that do not comply with the Statute of Frauds. Okay, a little bit of history of Statute of Frauds, guys. I have here, in 1677, charot, tagal-tagal lang, no? So, hindi na natin batahin yung mga history, guys. Doon na tayo sa Statute of Frauds in the Philippine setting. It is descriptive of statutes which require certain classes of contracts to be in writing to be enforceable. Of course, this statute does not deprive the parties of the right to contract with respect to the matters therein involved, but merely regulates the formalities of the contract necessary to render it enforceable. The statute simply provides the method by which the contracts enumerated therein may be proved, but does not declare them invalid because they are not reduced to writing. So here, in the following cases, an agreement hereafter made shall be unenforceable by action. So yung from letter A to letter F are unenforceable by action. Pero sabi nga dito, unless the same or some note or memorandum thereof be in writing, and subscribed by the party charged or by his agent. Evidence, therefore, of the agreement cannot be received without the writing or a secondary evidence of its content. So, ano bang ibig sabihin yan? So, sabi nga, agreements covered by the statute shall be unenforceable. Okay? Oo nga, yun na nga. The statute does not require that the contract itself be in writing. Okay? It is clear that a written note or memorandum embodying the essentials of the contract and signed by the party charged or his agent suffices to make the verbal agreement enforceable, taking it out of the operation of the statute. Now, let's go with yung ano mo yan? Second, those items that do not comply with the Statute of Frauds. By the way, what would be the effect of failure to comply with the formality required? Okay, the effect of non-compliance with the requirement of the Statute of Frauds is simply that no action can be enforced unless the requirement is complied with. So let's have here an agreement that by its terms is not to be performed within a year from the making thereof. No? Ang hirap-hirap maghanap ng example, guys. Pero ang ibig sabihin lang talaga niyan is, in order for a contract is within the statute if the time for the full performance of the contract exceeds a year. Okay? So, a contract is within the statute if the time for the full performance of the contract exceeds a year, although the excess is ever so little. So, the test to determine whether an oral contract is enforceable under the one-year rule of the Statute of Frauds is whether under its own terms, performance is possible within a year from the making thereof. If so, within a year daw, the contract is outside of the Statute of Frauds and need not be in writing to be enforceable. The fact that the performance actually may have taken more than 1 year after the making of the contract is immaterial as long as the performance is possible in less than a year under the terms of the contract. So, it is said that the 1-year period begins to run from the day the contract is made. So, sabi, assuming, say for example, S entered into an oral contract with B on October 10, 2020 for the construction of B's house to begin on October 20, 2023. So, in order for that contract to be enforceable, it must be in writing. Diba? Yun lang pala yun. Next, a special promise to answer for the debt, default, or miscarriage of another. Now here, any special promise to answer for the debt is required to be in writing or to be evidenced by some note or memorandum signed by the promisor to be enforceable against the latter. Thus, the contracts of guarantee, proper, and suretyship are covered by the statute. Okay, kinakailangan in writing siya. So, C, an agreement made in consideration of marriage. So, sabi dito, pag mga marriage, a marriage settlement is an example of an agreement in consideration. A donation propter nuptias, however, is no longer governed by the Statute of Frauds but by the formalities required in ordinary donations. So, take note, marriage settlements and donations propter nuptias are agreements made in consideration of marriage. So, for example, M agrees to build a house worth 1 million for W. So, if W will marry M, this must appear in writing to be enforceable unless M ratifies the agreement. The statute applies even when the promise to build the house is made by a third person to W, but a mutual promise of M and W to marry each other need not be in writing, for the breach of the mutual promise to marry, diba, is not an actionable wrong. Beatrice Westmer Amped. Okay, next. Letter D, an agreement for the sale of goods. For the agreement of sale of goods, guys, the statute covers both tangible and intangible personal property. Example, S and B mutually promise to sell and buy a laptop at a price of 12,000. So this contract must be in writing to be enforceable against either party unless there is delivery or partial or full payment, in which case it is taken out of the operation of the Statute of Frauds and the contract may be enforced even if it was made orally. Okay? How about letter E? Ba't ang haba-haba niya? An agreement blah unless the buyer. So, yan. Yan lang pala yung ibig sabihin niya. Na if it would exceed 500 pesos, okay, pasok na siya sa Statute of Frauds. Unless nga, merong unless the buyer accept. Okay. Okay, letter E. An agreement for leasing for a longer period than a year, or for the sale, or okay. Assuming R agreed to lease his house to E for 2 years. Okay. Example, I agreed to lease my house to GTM for 2 years. In order for this lease agreement to be enforceable, it must appear in writing unless it is partially executed. Finally, a representation as to the credit of a third person. Ano ba yung representation na yan? So, to bring the case within the operation of the Statute of Frauds, the representation must have been made by a stranger to the contract in which credit was extended, or as otherwise stated, the representation must relate to a third person's credit. Okay, thus representations as to the credit of the persons making the representation are not within the statute. How about yung third kind of unenforceable contract? Okay, what is the third kind of unenforceable contract? We have, finally, kasi check ko yung ibang books din na may ano. So, contracts where both parties are incapacitated. So, where only one of the contracting parties is incapable of giving consent to a contract, example, minor siya, the same is merely voidable. However, where both parties are incapable of giving consent to a contract, the same is unenforceable. Okay? So, what would be the effect of ratification in a contract which is unenforceable because both parties are incapable of giving consent? Express or implied ratification by the parent or guardian, as the case may be, of one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. Thus, the contract becomes voidable. But if the ratification is made by the parents or guardians, as the case may be, of both, take note of both the contracting parties, the contract shall be validated from the inception. Okay. Parang ang bilis-bilis naman. Yun na yun. Unenforceable contract, hindi. Mag-aaral pa po tayo ng mga cases. But of course, wag na lang yung mga cases. Just if you really have time, magbasa kayo, guys. You know, ito is, at the same time, nag-aaral din ako ng unenforceable contract. Just so happen na, may refresh din yung mind, body, and soul. Anyway, thank you for tuning in, and please feel free to send me a message for any comments and suggestions. If you have questions, guys, let us ask Attorney Padilla. I would really appreciate it. Let's help one another as a student of law. So happy reading, friends, and you still have long day tomorrow. So that would be all. Thank you. Please do subscribe. Charot! May pa-subscribe. Pag nalalaman si Seth.